Alright everyone, greetings and salutations, my fellow sovereigns. This is the Vocational Science of Freedom Saturday Night Civics and Sovereignty class, and tonight we are going to talk about having a right to travel binder in your car. So it'll be an aspect of self-governance, and there is a mega link in the chat room that will allow you to download all the information. The mega link is also in the show notes description on both YouTube and Odyssey. And if you'd like to join the Vocational Science of Freedom Guilded server, you can do so by going to the Vocational Science of Freedom YouTube page, clicking on the banner in the upper right hand corner here, where you'll be prompted to ask some questions to get into the VSOF Guilded server. I highly suggest that you download Guilded first, the application, instead of running it off of your browser. And also, if you'd like to join the Vocational Science of Freedom on Odyssey, it's odyssey.com/@VSOF:8, which is where we'll be posting all of the videos that YouTube does not allow to be posted any place else. Okay, so onto the folder. So this is the mega folder for this evening. I'm going to have this up here. This is everything that's in the mega folder as well, but I'm not going to be bringing it up through mega through the browser. I'm just going to be clicking on things here in the folder. But this is a reflection of everything that's in there. So just to go through the folders quickly, the court paperwork, all of this stuff is based upon wins that people have had in traffic cases. The first one is the arbitration award, where the VSOF status documents were used, particularly obviously the kill warrant, which has a much longer winded name, but we just affectionately call it the kill warrant here at the VSOF to shorten the name of it. And this is Drew's award information. It has the lawful lien against a judge's house in Colorado, and his arbitration awards, and also I put in an MP4 video of a discussion that we had when we were still back on Discord with Drew when he was talking about what he did to get that award. So it's the arbitration information. The next information is a case. These are transcripts of Amura's case that he got dismissed by just arguing in court. So you can take a look at those. Again, I'm not going to read all of these, but I'm just going over just on the top here what's in each of these folders. The next one is case dismissed by argument of the name. This is something that somebody filed in Colorado, which worked. There's the dismissal letter, which shows that the case, yes, did indeed get dismissed with the court seal on it, and it has the paperwork as to how that happened as far as the affidavit, and it is in a Word doc file so that you can alter it as need be. It's not redacted, so it still has all his information in it. So just be aware of that and make sure that you go through and alter it, fix it, tune it up to whatever you need to have it for your case so it works. Next one is a case dismissed. This one is a bond versus, where they argued bond versus U.S. Bond versus U.S. was a 10th Amendment argument at the Supreme Court level, and I'm not going to get into the intricacies of the case, but basically it's saying that you have the right to argue the 10th Amendment, to say, no, I am not under the jurisdiction of Congress and the rights that are secured to us. One of them, it definitely can be argued that it's the right to travel. Now, this was bond versus U.S. was not specifically a traffic case, but there is two documents. I did one by notary and one by quorum, however way you want to do it, and they are they're open. So again, you're going to have to fill it in with your information. But I'll just open this up really quick. This is the PDF form of what it looked like. Of course, I have my own little notes in here, which you guys can read. But this is what it looked like. So verification of complaint. It was basically 2 sentences. My legal entity's name is the all caps thing, defendant herein. I have read but do not understand the attached foregoing complaint, blah, 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 which basically he's saying I'm not willfully entering into contract with you, yada, yada, yada. Further, the affiant saith not. That was it. That's all that thing said. And then the general affidavit is getting a little bit more specific into the fact that he's arguing and saying, look, I'm the executor, and I wouldn't say beneficiary, I'd say heir here, but anyway, he gets the point. I'm the executor and beneficiary legal person, da-da-da. I believe that Oregon Motor Vehicle Code, yada, yada, and whatever, are in violation of my 10th Amendment bond versus U.S. 2011 on appeal, labeled Exhibit A. Now, I gave everyone the entire bond versus U.S. case, so you can literally just print this out. It's 59 pages, so you can literally print this out and use this as the same exhibit that he used in his case, which is the Exhibit A. Okay, so to continue, and so I believe that all the vehicle codes are in violation of my 10th Amendment rights and my common and natural law rights. I'm of the opinion that all statutory regulations, meaning Oregon revised statutes, and obviously change that to be your state, are in violation of my common and natural law rights. I am not a public servant, and any claim to the contrary must be proved by payroll records and my alleged public service title and sworn under the penalty of perjury and full commercial liability. This is the point where he's basically arguing in a kind of a roundabout way that he's not a federal employee, or federal personnel is actually the proper term in USC. So anyway, I do not operate a for-profit business using the roadways, highways, streets for any city, county, or state of Oregon using a commercial motor vehicle. So he's saying I'm not in commerce. I claim common law jurisdiction, so he's making a claim. I do not consent to this unlawful proceeding, and I am waiving the compelled benefit, meaning he's not going to take a benefit from them. He says he's not going to take compelled benefit, but he calls himself a beneficiary up here, which is kind of I would say it's a contradiction. So I get rid of the beneficiary part up here, because this is what you want to say. You're saying I'm waiving the compelled benefit, or you're saying I am I'm waiving all benefits. You could say that if you wanted to. And then he continues, I do not surrender any natural common law rights in this proceeding. Right. So he's saying, by saying that simple sentence, you're basically saying that you do not waive your right to a court of record. Right. Meaning a court that proceeds according to the course of the common law, where the tribunal is independent of the magistrate, and so on and so forth. You guys know the rest of those. And if you don't, I have the rest of that information regarding what a court of record is in the law of the case, which is also in this folder. And then he finishes off, I do not plead to courts of contract. Exactly. If you see, you never enter a plea. If you ever see, the only thing you ever want to say, if they kind of force you to say, well, you're going to have to say something, say, I'm innocent. You say, I am innocent. That's all you have to say. You do not have to plead. You don't have to say, I plead innocent. You just say, I am innocent. Stop, full stop. That's it. And that should be all you ever need to say, because you have the right to do that. And so therefore, instead of you saying I am guilty or not guilty, which is a contractual obligation, if you will, under Roman civil law, where if you do plead to a court of contract, either being guilty, non-guilty, or no contest, then you're saying to this foreign Roman civil law inferior court that you are consenting to be under the jurisdiction of the statutes, acts, ordinances, and codes which they're bringing against you in whatever shape or form, because you have then agreed to give a plea based upon those charges. And so you never want to do that. It's just one of these little word game tricky things that you never want to enter into contract whilst you're in a court situation. Okay, so then he signs it. Randy J. Carlson, executor, beneficiary. Again, I'd get rid of the beneficiary part. I'd get rid of the all rights reserved part, because you only want to put down the all rights reserved under a signature line if you're signing something that they're forcing you to sign, meaning like a jail bond or even the license application, right? When they're forcing you to sign something, that's when you put all rights reserved. You do not put it on a document that you... Now, of course, this worked, right? But I'm just saying that you want to stick away from that only in a situation, or sorry, you only want to use it in a situation where they're forcing you to sign something. You do not use it on something that you're signing yourself. So then he's got general delivery, yada, yada, yada. Okay. And then he has his notary public. And then this was the letter that they sent back to you. The court has dismissed your case. You have no further obligation with the court regarding the citation. If you have any questions, please call whatever phone number. So that was the letter that he got back. Okay, so that's that court case. And so all the information's there. Bond versus U.S. is there. And like I said, you can either do it notary or quorum, whichever one you like. And so that's that case that got dismissed by arguing Bond versus U.S. Other court tools and documents. So there are, hold on, I'm getting a little bit of feedback here in the, that's strange. Is anybody hearing anything in the background? I just want to double check that real quick. It sounds like a little hiss going on. Anyway, it's not going to pop up. It should be okay. All right, so where was I? Okay, other court tools and documents. So this one's a common law right to resist unlawful arrest in Wisconsin. Just some court information regarding that. This one is the law of the case, which is where I have all of the traffic information, traffic case law, I should say. And there's a lot more information in this law of the case. It's a document that we've covered at times in the past, but I'll just kind of go over it real quick here. So this is the law of the case. So this is something that you would file if you were filing a counterclaim. Oh, you do hear the hiss. Okay. Is everybody, not everybody's muted. Can you guys make sure you self-mute just to make sure that nothing's coming through? I can also just turn off the internal sound, so at least it doesn't get recorded into the tape. So okay, anyway. Okay, so back to the law of the case. So anyway, this law of the case is what you would file if you were filing a suit against them in your court of record. And I'm not going to get into how we do a court of record. That's like a whole day class in of itself. But anyway, this is the document that you would file as far as what your law of the case is when you're defining what the law of the case is, or I should say decreeing the law of the case. So this is what a court of record is, the A, B, C, D, and very far down here, because this is a 27-page document, I'll skip down to where it is. Down towards the bottom side of the document, there are multiple different court cases regarding the right to travel. So I'm not going to read all these. You guys can read them on your own, but some of these are also reiterated in the documentation that we're going to have in our binder, right? So in the binder folder for carrying with you in your car, a lot of these will also be in there. So I just want to mention that. And so now I'm going to go to the list of various different things that you can keep in your car. Again, I might update this list later because there are a few things in here that I think, or there are a few things missing in here that I think I'd like to add. But for now, this is the best list that I have. So anyway, Mumbles helped me put this together. He has one of these whole binders and keeps it in his car at all times. And this is this picture right here that I have on the front. This is what he puts on the front of the binder. Now, what I would do is I would have everything in this binder in a way where if you ever get pulled over, you just give this whole entire binder to the cop and you say, I am placing this onto the official record regarding this case, like right then and there, and that you give it to him and say, I have given you notice of everything that is contained within this folder. I have a complete copy of this folder at my house, and you are getting a complete copy of this folder now, however you want to say that, so so everything that's in here then has to be immediately entered into the record. So they have notice at what's called first instance. Okay. So this is what he has on the front of the copy, or front of the binder. Right to travel. If the state does convert your right into a privilege and issue a license, and a fee for it, you can ignore the license and a fee and engage, it should say, and engage in the right with impunity, I believe. The Mumbles, if you want to look at the video, just go to the live link up top, the YouTube link. That's what I'm showing it live. So this is the picture, and you guys can choose a different picture if you want to. You can make your own picture. You can pick a different court case if you want to put it on the front of the binder. Perfectly fine. Just something that shows right in the beginning that the first thing that they read is a court case showing that you have the right to travel. That's what I would say would be the most important thing to do that. So next, inside the folder, I'd make sure that you have, and this is of course something you always want to make sure you have done, is all of your Vocational Science of Freedom status docs. This binder is imperative to have all of the, well, not all of the status docs, but the ones that I have listed here in the binder, so that you can give them a certified copy of each of the listed documents here that I have. So a certified copy of your Declaration of Nationality from the VSOF status docs, make sure, you know, to be able to give to them. A certified copy of your fee schedule, a certified copy of the kill warrant, which the name of it is actual lawful claim of title, will, execution of will, declaration of status, appointment of trustees and standing orders for same, and a certified copy of the ordinance of the estate, which is a short document which basically has all of the list of all of the rest of the public record numbers of all the rest of your status docs on it, so that they then have first instant notice of everything that you've recorded on the public record. So this, what I'm looking at right now, is this is the handbill of short descriptions of the status docs, the estate documents. Okay, so you don't need to put all these into the binder, but the fee schedule, the kill warrant, declaration of oath of citizenship, and the ordinance of the estate. So basically 7, 8, 9, and 10 are the ones that you want to be able to have copies of to give to them when you hand them the binder. So there's, you know, make sure you go get certified copies and just be ready to give that entire binder to them and expect never to see it again. Now, is that going to cost a little bit of money to put together? Yes, it is. However, if you can give them an entire binder and completely protect yourself with one binder of information that they then have to put on the record as to that, yes, they were given notice, yes, because then you can cross-examine the cop when you're in court and say, did I hand you a binder? And he'll say, yes. Did it contain such and such? And he'll have to say, yes, it did. Right? And then you can start reading all the court cases that then he, in court, has to admit that he had full knowledge of before he decided to give you a ticket, which of course would be unlawful, and it would prove that he shouldn't have done that, and that gives you prima facie evidence against him that he knowingly and willingly exceeded his jurisdiction. So anyway, so that's that. And then on to, so those are the aspects of things that will be given from the VSOF status docs. Also, a copy of the U.S. Constitution with the Bill of Rights. I would suggest getting a small little pamphlet, book, handout thing that'll take care of that. Also, the Arizona Senator Wayne Stump letter. This one I will bring up because we've talked about it before, but it shows something extremely important. Wait, hold on, that's kind of the fuzzy version. This one is a kind of a better one. This is, I know this is still, again, a little bit fuzzy, but it's clearer than the other one that I had. So anyway, what is this? This is a letter that was written by a state senator, Wayne Stump, from Arizona, way back in 1985. And it's a letter to, he's addressing this letter to a Mr. Ralph Milstead, Director of Department of Public Safety for the state of Arizona, which basically is, you know, everybody that deals with the training of state police and so on and so forth. So he says, Dear Director, it has come to my attention that numerous individuals in our state have rescinded all of their contracts with the United States federal government. Exactly. That's exactly what we do with the VSOF status docs. We say, nope, I don't want any of your contracts. I'm out of here. The state of Arizona and each of its political subdivisions, right? Because we're removing ourselves from any contract that they might think that they have over top of us. Establishing themselves as free men under the organic national constitution of the Republic of the United States of America. Consequently, they may be driving without auto registration, driver's license, or any other evidence of contract. And I wouldn't say driving here, he misspoke, but anyway, you get the point. Because many law enforcement personnel may be unaware of the contractual nature of auto registration and driver's licenses, it is conceivable that this situation may lead to confrontation between these individuals and law enforcement personnel. I urge you to inform yourself and your personnel about this matter as soon as possible. If you would like to be briefed by someone knowledgeable on the subject, please contact me. Right, so what is he saying? He's saying, hey guys, it's all contractual, and if you didn't know that, come talk to me because I'll have to explain it to you. Then he says, in the meantime, inasmuch as this procedure is entirely appropriate when properly carried out, right, which is what we do, I would like to be personally notified of every such instance of confrontation in order that the persons involved and the public officials involved may be apprised of the correct procedure and the appropriateness of their actions on the part of each concerned. My office phone is da-da-da, and I'm requesting to be notified of the names and incidents along with addresses and phone numbers of participants of any such confrontation arising from the exercise of a person's freeman status in order to evaluate the outcome of properly rescinded contracts. Signed, Senator Wayne Stump. So I have it that way, and then I also have another one. This one's a little bit fuzzy. This is in a PDF form. But there is another part. So that was the first part. So there is like this kind of second part of it, which is unfortunately it's upside down. But it's basically just that somebody got a copy of this and then they got it notary stamped to say that it was an official copy of the original letter. So that's that, and I would definitely keep that in the binder as well to make sure that you have given that to them so that they know they can't argue that yes, this is a contractual situation and that you're not under contract, that you don't have any contracts with the corporate state, which is something that I usually say to them right off the bat. You know, when they come and say whatever they say, it doesn't really matter if they say driver's license registration or if they say, you know, hot dogs and hamburgers, I don't care. I simply say, the first thing I say to them is that I do not have any contracts with the corporate state. So what is your business with me? And that usually shuts them up pretty quick because then they're made aware that you're aware that everything is contractual and is all based on consent, which of course you're not giving consent, right? Okay, so with that, let's get back to the letter here, or get back to the list. So make sure you have the Wayne Stump letter in there. A copy of the list of terms with authority given. That is number 6. And this is what Mumble's compiled of definitions of various different terms in regards to this whole issue of the right to travel. So driver, one employed. Bouvet's Law Dictionary. So if you're not employed, if no one's paying you to do what you're doing, then are you a driver? The answer is no. Driver, one employed in conducting a coach, carriage, wagon, or other vehicle. Driver, one employed in conducting or operating a coach, carriage, wagon, or other vehicle with horses, mules, or other animals, or a bicycle, tricycle, motor car, though not a street railroad car, which would be like a trolley. Black's Law Dictionary, 3rd edition. Black's Law 4th, just again, one employed. And the activity licensed by state DMVs in accordance with which individuals must submit personal information to the DMV, the operation of motor vehicles is itself intricately related to interstate commerce. That's Seth Waxman, Solicitor General, U.S. Department of Justice, brief for the petitioners, Reno versus Condon. And I have double checked that and shepherdized that case, and that is correct. Next one is USC. This is under aircraft and motor vehicles definitions. When used in this chapter, the term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways and in transportation of passengers and property, or property and cargo. So again, used for commercial purposes. That is the point. If they have no proof that you are using the roadways as a place of business, you cannot be charged with a traffic ticket unless you've actually done damage, harm, loss, or injury to someone, like running into them. That's different. This is Motor Vehicle Laws of Florida. The term motor vehicle shall include all vehicles or machines propelled by any power other than muscular, used upon the public highways, but not over fixed rails, for the transportation of persons or property, for compensation, that's the point, either as common carriers, private contract carriers, or for hire carriers. And that's just another term that or another sentence that I would tend to use in court, either in cross-examination or just in your paperwork. Say, is there any evidence, or has the prosecution produced any evidence that would suggest that I was engaged as a common carrier, a private contract carrier, or a for-hire carrier on the day in question? Right? You can say that just in open court. You can say that as a direct question to prosecution. You can say it as a cross-examination to any cop up on the stand. Did you find any evidence that I was blah 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 blah? Right? You could say it like that to the cop for cross-examination. Okay, to continue. Traffic. Webster's Unified Dictionary Encyclopedia, International Illustrated Edition. I wouldn't necessarily use Webster's, but point is, business or trade, commerce, transportation, the movement of vehicles on street or highway, as the traffic is very heavy today, right? So traffic is about commerce. Traffic, bouviers, commerce, trade, sale, or exchange of merchandise, bills, and the like. That's traffic. Traffic, blacks, third, commerce, trade, sale again. So traffic is trade and commerce. Traffic, trade, commerce again. Traffic, trade, commerce again. Transportation, Black's Law third, the removal of goods or persons from one place to another by a carrier. And again, who's a carrier? Someone who's using it as a place of business, using the roads as a place of business. So, under Interstate Commerce Act, transportation includes the entire body of services rendered by a carrier, again, someone in commerce, in connection with the receipt, handling, or delivery of property transported, and includes the furnishing of cars. In a general sense, transportation means merely conveyance from one place to another. But I wouldn't mix those two up, right? So don't ever try and say, oh, well, transportation means I'm just traveling. Nope. Conveyance, traveling, I would say, nope, transportation means, again, for hire. And it always goes back to, do I have a contract with the corporate state that allows me to transport things as a for-hire carrier or contract carrier on the roadways, using the roadways as a place of business? Either that's yes or no. And two, am I actually doing it, right? Because the contract, meaning the driver's license and the license plate and the tags and whatever, even the registration of the thing, is the prima facie evidence to their side that you are somehow engaged in commerce, so that you intended to engage in commerce, so that you possibly were on the day in question. Well, guess what? If you don't have any of that shit, then there's no presumption on their part. There is no prima facie evidence that you were. So I'll skip down here a little bit. Some of these court cases. Prior to November 2nd, 1926, statutes of 1925 imposed a license tax on those operating motor vehicles over the public highways for hire. On November 2nd, 1926, the people adopted an amendment to Article 13, Section 15 of the Constitution, exchanging the tax rate on carriage of passengers and on transportation of property and relieving the carrier of municipal license and taxes. The amendment contained the provision that such taxes shall be in lieu of all other taxes and licenses upon the property of such companies. Right. Again, just proving that this is all about commerce and companies doing things. Next one, it is obvious that those who operate motor vehicles for the transportation of persons or property for hire enjoy a different and more extensive use of the public highways. Such extraordinary use consists of natural distinction and a full justification for their separate classification and for relieving them from the burden of license tax. Those who merely employ the public highways for the transportation of their own property, right? So they're not using the roadways as a place of business for someone else. Next one, the exemptions provided for in Section 1 of the Motor Vehicle Transportation License Act of 1925, such and such, in favor of those who solely transport their own property or employees, or both, and of those who transport no persons or property for hire or compensation by motor vehicle, have been determined in the Bacon Service Corporation case to be lawful exemptions. So, lawful exemptions to what? Lawful exemptions to having to have a license to do so. That's the point, right? So if you're transporting your own stuff, you're not using the roadways as a place of business, and therefore you are exempt. Okay, that's that document. Next one here is the AMJR and Corpus Juris Secundum statements. Again, you can put these into the binder either all together or just, page after page if you want, or you can separate them with headings up top and say, okay, this is Corpus Juris Secundum, this is AMJR, if you want to. But here's Corpus Juris Secundum. Personal liberty, or the right to the enjoyment of life and liberty, is one of the fundamental or natural rights which has been protected by its inclusion as a guarantee in the various constitutions, which is not derived from or dependent on the federal constitution, and which may not be submitted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as the right of private property, or as occupying a preferred position as contrasted with property rights, and is regarded as inalienable. So, your right to travel is an inalienable right. This concept is further amplified in 11 AMJR constitutional law, wherein it is said personal liberty largely consists of the right of locomotion, to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens, meaning you're obviously not running into people as you're going from point A to point B. The right of a citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege, which may be permitted or prohibited at will, but a common right which he has under the right to life, liberty, and the pursuit of happiness. Under the constitutional guarantee, one may, therefore, under normal conditions, travel at his inclination. Now, what does that mean? Travel at his inclination. That means you can be on whatever drug you want. Doesn't matter. You can be smoking marijuana, you can have a couple beers, whatever. The point is, at his inclination. That's however you want to travel. As long as you're not running into someone, you have not caused any damage, harm, loss, or injury to anyone. So, just be mindful of that. Along the public highways or in public places, and while conducting himself in an orderly and decent manner. Right. If you can do so under sub-drug, then fine. If you can't, then don't. Neither interfering with nor disturbing another's rights, meaning that, exactly, you're not running into someone else when you're going from point A to point B. He will be protected, not only in his person, but in his safe conduct. Right. So that's Tech Lines Incorporated versus Danforth. Looks like it's Mississippi. In Barber versus Walker, as Oklahoma case, the distinction between the right of a citizen to use the public highways for profit rather than commercial purposes is recognized. Yep. This is Dickey versus Davis. The right of a citizen to travel upon the roads and highway and transport his property thereon in the ordinary course of life and business differs radically and obviously from that of one who makes the highway his place of business and uses it for private gain in the running of a stagecoach or omnibus. The former meaning the right, is usually an ordinary right of a citizen, a common right, a right common to all, where the latter is special, unusual, and extraordinary. As to the former, meaning the right to do so, the extent of legislative power is that of regulation, but as to the latter, its power is broader. The right may be wholly denied, or it may be permitted to some and denied to others because of its extraordinary nature. This distinction, elementary and fundamental in character, is recognized by all authorities. So again, can they regulate traveling? No. Can they regulate commerce? Yep. How do they do so? By you wandering in there and begging for a license. And then that gives them prima facie evidence that you were actually engaged in commerce on the day in question. Now, doesn't mean you were. It's just a presumption. And again, we all know how presumptions end up screwing everybody. Okay, next one. This is the U.S. Supreme Court cases on the right to travel. This looks like it was just an article, and it has many of the same cases that I have already stated, and many more. So I'm not going to read all these, but you guys can take a look at these at your own leisure, and also add them, obviously, to your binder. So when you're giving this binder to the land pirate, they're getting notice of all these cases. And then if they continue to act afterwards, well, they had notice. They knew they shouldn't have done that. They knew that they didn't have jurisdiction. And they knew that you had right. Okay, so the next one, this is a small little picture. I'll blow it up here, but we might have to get a different picture of this or a better picture of this. And the other thing about this one too, Bond versus U.S., that obviously was the court case that I was talking about in the that was used in the court case to squash that other ticket. This is not a direct holding from that case. It's just kind of someone's loose interpretation of the holding. It says in 2000, the Supreme Court held that the American people are in fact sovereign and not the states or the government. Well, it's not exactly what they said. The right of the people to do what they wish to based upon the 10th Amendment is more along the lines of what the point of the case was. The court went on to define that local and state federal law enforcement officers were committing unlawful actions against sovereign people by the enforcement of the laws and are personally liable for their actions. Well, enforcement of statutes, acts, ordinances, and codes that the people have not consented to, yes, that was more along the lines of what it said. So, anyway, you can use that or not use that as you want to. I believe this Doc 4 was, yeah, this was one, I wasn't exactly sure. I asked Mumbles where he got this from because I don't know what book this came out of. And it's always a good thing to grab at least the actual authority as to where you are pulling your information from, particularly if you're going to use it in a court case. But just down here a little bit farther, it said, indeed, an apt description of the right of locomotion was set forth almost 60 years ago by the Ninth Circuit when it stated that personal liberty, which is guaranteed to every citizen under our Constitution and laws, consists of the right of locomotion, to go where one pleases, and when, and to do that which may lead to one's business or pleasure, only so far restrained as the rights of others may make it necessary for the welfare of all others, meaning obviously don't run into them. That's the damage, harm, loss, or injury thing under the common law. The rights of others that's your rights end where others start, basically. It's the end of someone else's nose aspect. So you can read the rest of that if you like. I just need to find out from Mumbles or someplace where this was actually pulled from so that we can use it in a court case for authority if we need to. And this next one I actually have to find a better copy of. It's a DOD regulation, but it's way too small to read. And even if I blow it up, then it gets too fuzzy. So we're gonna have to find that DOD regulation. I do see Yikwo v. Hopkins. I know that case. I can barely read it. But anyway, we'll have to find that someplace else to get a clearer picture of it if we want to use it. This is Hatfield versus London. This is the Washington case. Was this the one where the judge goes off on him? No. There's one Washington case where one Washington judge, basically, it might be this one, where he gets, yeah, here we go. The complete freedom of the roadways is so old and well established a blessing that we have forgotten the days of the robber barons and toll roads, and yet under an act like this, arbitrarily administered, the highways may be completely monopolized. If through lack of interest the people submit, then they may look to see their most sacred of their liberties taken from them one by more or less rapid encroachment. That was where the judge kind of had enough and stated it in this way, which I always found this quote to be a more powerful, in your face kind of thing, because he's saying, look, you know, these people are being robber barons, and if you're not going to stop them, well, you get what you deserve, kind of thing. Okay, so these are the things in the list, and again, I'll pull up the list one more time. So we have all of these things, this information. Also keep a photocopy of the front of the certificates of titles to your truck, car, and or trailer. Now, here's the thing: what you really want to have, what you would prefer to have, would be the MSO. If you bought your conveyance directly from a dealership, you have to go to and here's the thing about this, about getting the MSO, from my understanding. From my understanding, you have to go to another state compared to the state that you live in, and then say that you are then importing that car into another state, and then you will be able to actually get the MSO, which stands for the Manufacturer Certificate of Origin. If you have the Manufacturer Certificate of Origin in your hand, you own that car. That is the actual title to the car. But what usually happens is that when someone goes and purchases a car first time, what the dealership will do is they will take a look at your driver's license, and if it's of the same state, what they'll do is they will then fax or ship or mail the MSO to the Secretary of State of the state of which you show them a license, and then the Secretary of State holds the MSO, and then you go and quote-unquote register the car at a title company, and you get what's called a certificate of title. A certificate of title is not the title. It's your right of usufruct, meaning your right to use the thing but not own it. So you get equitable title, which is another term for this. So you get equitable title, or the right to use it, but you do not have legal title, which would be the MSO. So, but either way, if you don't have the MSO, then just keep the certificate of title if that's all you've got, because the land pirates do get pissy and they want to be able to see that it does exist, and yada yada yada. But the MSO would be better. Let's put it that way. And then I'll have to get another copy of the DOD, or sorry, the Department of Transportation section regarding those laws. And that's pretty much it that I have for now. This is what Mumble sent me, and we can expand on it if necessary, or improve on it. But for minimal information, I would say that would be what you'd want to put into your binder. Now, and now I'll open the floor up. Does anybody want to comment about anything as far as this particular subject, or Amaru, do you want to talk about your court case that you had? If you want to describe the transcripts, which of course are yours, the ones in the court paperwork for dismissal, or anything else that anybody else wants to bring up.
Hey Zen, I'd like to ask about creating your own title via the public record for your automobile by creating one. I've done it before for my last truck I had, but I ended up selling it. But I created one and put it on the public record. Just use that as the title because I was not able to get the MCO.
Okay. I do not have a process for it, but if you did it, I'd be happy to take a look at that and share it with everybody else. I also know that somebody else on here, gentleman by the name of Silence, I believe, what he did was he transferred all of his vehicles from private, from the like the equitable side, the private side of ownership, or the private side of use, I guess, regarding the certificate of title. What he did is he transferred all of the ownership to his house, and he has like this. He has a large. I've seen it actually because I've met the gentleman. He has a large leather bound, basically record book of his house, meaning all of the things that he's done for his house, the transfers and the various different other things, and he records everything in this record book. And so what he did was he transferred it from basically the dead estate name to his house. And I don't know if he created a title for it or not. I'll have to ask him. But
I believe what he did was he actually just kept photocopies of the titles showing that they had been transferred. And in many states, when you actually do transfer a vehicle from the private equitable side, you basically
what you cut out.
the titling office doesn't want to deal with it, but basically you send it back into them saying that, hey, this has been transferred from the estate name into the trust name. And they basically, or the trust, or like the estate, the house,
Or the house, yeah.
the
Yeah.
yeah. And basically, they essentially mark it and they like put a seal on it or something, and then they send it back to him. And he basically had photocopies of all of that and that folio.
Okay, so he did send something to a title company and they basically put their seal on it and sent it back to him.
Uh, as I understand, it was actually like your standard equitable certificate of title nonsense sent into the same office that processes that stuff, and then they probably had to have somebody higher up go look up the proper way to do things. But basically, they put the office's stamp seal like a notary sort of would do on it, is what it looked like.
Okay.
Because most of your titles, how they'll have like 4 or 5 lines for transfers on the back. You basically transferred it from the dead estate name to the house or trust entity, and then mail that into like the actual titling office of the state, right? And then they sort of like stamp it, acknowledge it, says, okay, this is out of our hands now, and this is technically like legitimately 100% private property. And you basically had photocopies of those where you could actually see the stamp, including like the embossed raised stamp as
Okay.
well.
Okay. Because I just barely, I looked over his book, but I didn't, I probably should have taken pictures of it, honestly, when we were there at that meeting. But, okay. So now I know when we have it for posterity what he did. I'll ask him again, or I'll get a hold of him again and say, hey, can you maybe write up like a short handbill of exactly what you did do? I'm sure he'll be happy to do that. Um, and then I can add it to this information in the folder.
Yeah, I've been looking at some of that here in my state, Missouri, and that appears to be the same process for here.
Okay, great. Then that definitely should be something that we lock down and make clear as to how it needs to happen so that everybody can, follow an ABC through it and just and get it done so it does make sure that it's in the private side.
My only real question about all of this stuff is how many times do you actually have to fight and object to them trying to do all of these things?
Well, Amaru can speak to that. He's kind of gotten, I mean, like his local sheriff knows him and they don't even like bother him anymore. And I know other people that have done that too. They've had conversations with their sheriff or they've sent the sheriff notices and either sent them also information regarding the fact that the property is private, um, or they're very diligent about having a binder like this and uh, having a private plate of some sort. Either they get it from somewhere that says private or whatnot, and he puts things like bumper sticker on it that says not for hire or something to make it clear from the backside that I'm not engaged in commerce, and that's at first instance, because of the cameras that the cops have, it shows that you're not in commerce. And I guess it really just depends on who you're dealing with, because they're all just government agents. They're just doing their thing, but they are aware of the fact that it's contractual in nature. In fact, there was a phone call that I had. A friend of mine called the sheriff after he'd served him with the dock set, and he had a conversation with. Actually, the sheriff called him and he said, "So, what's all this stuff you served me?" And he said, "Well, I have established my house, and this is a contract basically showing that if you or any of your deputies attempt to administer anything of my estate, that you will then willfully enter into the contract." And then they continue to have a conversation back and forth about the difference between right to travel and the difference between the contractual nature of the driver's license. And that was pretty much it. So he had a conversation with his sheriff and kind of took care of it that way. There's really no one way to do it. It's just you just use all the tools that you possibly have to inform them, and then they're informed that they have notice. So
Yeah, I'm just asking now. I'm supposed to go to a pre-trial conference later this week for this very topic, and it's one of those things where, like, I inform the female officer as well as the uh, actual officer that was assisting her, and I also put the prosecutor and the judge on notice. The judge still pleaded for me and basically said, "Oh, this is mandatory. I have to show up, or an arrest warrant will be filed." And I actually went to one last month where I basically just didn't say anything and just sort of sat there, and then asked if when the last time to actually file motions would be, and he was just like, "Oh, that will be today." And I'm like, "Okay, well." I didn't really know that. I don't have all of my status docs done. I'm still waiting on birth certificates and things, and I'm just trying to sort of figure out the best way to sort of fight mine going forward.
well, you could certainly use the documents that I already put into the folder, like the 3 cases that got dismissed by different ways there. You can look at all those and use those tools. You can either write out the motion to dismiss based upon the name, which would be lack of impersonum jurisdiction. You could write out the affidavit for the bond versus U.S. and file that the way it is. Obviously, change it to your case, and at least put those in to have something for not only affidavit but also for motion to say, hey, look, I'm not consenting to all this, and I don't consent to the jurisdiction. And another thing you can say too in court is that you do not consent to the transfer of jurisdiction, which is 18 USC. I'll type it out. It's 18 USC 4108. Oops, hold on. So 18 USC 4108. And what that says is it's basically the name of the code is verification of consent of offender to transfer to the United States. Because you got to remember that these are basically all territorial courts. They're all private for-profit courts being run by, little corporations, and it's all by consent. So you have to consent to that transfer to be transferred to the United States. Um, so that's something that you can just say open in court that, Your Honor, I do not consent to the transfer of jurisdiction to the United States as per 18 USC 4108.
Well, I said a lot of that stuff in a lot of other ways. Although, it's one of those things where, because I said it in a very abbreviated fashion, without delving into all of the specifics that the officers of the court should actually be aware of. I think it was one of those things where they're trying to sort of see if I actually know what the fuck I'm talking about, and I'm just going to show up and, sort of go along with whatever the hell they're doing anyways. And I'm just sort of wondering at what point do I actually get to take them to court for the violation of my rights, administration of my estate, that sort of a nonsense.
Well, if you wanted to do that up front, one of the first things that you do want to do, this is now you got to know how to do this, but is to file a countersuit against them, because you file a countersuit for trespass and trespass on the case, stating that they've exceeded their jurisdiction, and you are filing suit against them for damages for that trespass. Otherwise, you're playing in their Roman civil law court, in a sense, with the motions to dismiss, following their rules of court, to bring it up and say,
would it already be too late for me to do that?
no, too late would be a situation of, like, judgment. It's kind of late if they already have judgment against you, but anytime up before judgment, it's not too late to do that. It is always better to do it at first instance, so that when you walk in there even like at arraignment, yeah, you say, because arraignment is all about them acquiring your consent. Yeah. For your consent to be under the jurisdiction of the Roman civil law.
Yeah, I actually, I went in with all of the, sui juris and appropriate persona, and I had like 2 paragraphs worth of stuff in one paragraph that I basically breezed through super quick. And I was reading it, stumble fucked a couple of things once or twice, and then when the judge says, "Okay, I'm going to enter in a plea of not guilty or whatever," I said, "I object. Your administration of my estate. I do not wish to enter a plea." And he cut me off real quick and basically said, "I'm entering in a plea of I understand or acknowledge or something like that, and but I'm entering in a plea of not guilty to you, and you will have a pretrial conference on such and such a date that is mandatory if you do not."
Yeah, that's at that point in time when they get into that argument, you say, "Your Honor, I am innocent. I do not plead to courts of contract." And
Okay,
and if
because I missed that, I've lost out, or
well, no, you can, every single time that you go into court, you can reiterate the fact that you do not consent to anyone else entering a plea for you, basically acting as, parents patriae or administration of your estate, to do it for you, and that any continuation of administration of the estate binds them to the contract of which they've been served. But of course, that would require that you do serve the kill warrant on the court and or the judge in chambers. But yeah, there's many different ways to fuck with them. There's no 100% right or wrong way to do it, but when you have all of the tools available to go at them, it's a good idea to just use every tool you have, and particularly from the start, to make sure that at that first instance that you make it aware that you did not consent to the jurisdiction. And if you want to put in a formal objection, you can write a formal written objection saying, for the record, that you do not consent to the transfer of jurisdiction, that you did not consent to anyone entering a plea on your behalf, and that anyone attempting to do so is an administration of your estate, which you do not consent to because you have come of full age and you are not an infant, as per 1 USC subsection 8, definition of person.
now, do I basically have to pick one tack and stick to it, or am I actually capable of using more of a scattergun approach and actually being like, letting them know, serving them with the, I don't consent to the transfer of jurisdiction, as well as doing all the other things. And I mean, is that help or harm?
But no, every single thing that you do, whatever it is that you do, are separate issues. And so you make sure that you do not allow them to move forward until each issue has been answered or settled. One way to state that in court is that you can ask the court. You say, "Your Honor, has the matter of jurisdiction passed?" What that means is that has the court passed on the question of jurisdiction, right? And if so, then they've got to prove how. And if they don't, then they can't move forward. But yeah, every single thing that you do, whether it be a motion to dismiss, whether it be the counterclaim or countersuit against them, whether it be the fact that you don't consent to the transfer, all these things are separate issues, like in personam jurisdiction, subject matter jurisdiction, the facts, whether you were actually engaged in commerce on the day in question. All these things are things that you always make sure that you continue to stand on at all times, so that nothing's ever waived. And that's another thing you can say too. You can say, "Your Honor, I do not waive any right at any time," which would also include your right to speedy trial as well, and everything else that goes along with what's protected under the Bill of Rights. And no, rounds, that doesn't work, by the way. It doesn't make any difference that if you accept the bill or accept the ticket. In fact, what you want to do is the second you get the ticket, if you actually were forced to sign it, within 72 hours, what you want to do is write
Conditional acceptance, yeah.
No. What you write is that you write on it that you rescind your signature for cause. That's what you write across the ticket and send it back to
I
them.
did not actually sign the tickets. I wrote under duress.
Okay, well that's fine. Then you never entered into the contract to begin with. But no, you never. The exception of the accepting of the bill doesn't do anything, right? That's
I
all.
understand.
Yeah, that's all that accepted for value nonsense that doesn't ever work. It's pointless. The other thing you could do is also file a FOIA request, or actually it'd be State Open Records Request Act because it's not federal. File a State Open Records Request Act on the case for the bonding information. If you can get the bonding information, you can contact the bonding company and cancel the bond, and then the case is over, no matter what they do. Because this is all based around their capacity to create billions and billions and trillions of dollars in bonds. And every single bond for the court case is always done through power of attorney. But because the bond, yeah, exactly. So because the bond is in the estate name, you can go to the bonding company and say, "I want to cancel this bond," and they have to do it. And once the bond's canceled, then they have full 100. They then have 100% liability on their ass, and they will get rid of that case as fast as they can because they do not want that on them. But that bond that they create through power of attorney, presumed power of attorney, is how they end up putting you underneath it. It's not just you say numbers. You say this signature is rescinded for cause without dishonor at a 45-degree angle on it. That's what I would put on it. And that's if they forced you to sign the ticket. But of course, if you do sign it under duress, of course that kind of gets rid of the signature anyway because it's not actually there under law. But if they ever pay attention to that, is
Well, there's no actual signature. The only thing written in the signature line are the words under duress.
yeah, right. So that was where you did not enter into the contract. And if you do that, then you make that a point in court as well and say, Your Honor, I've never consented to this ticket. I have not entered into contract. I signed it under duress. And and enter it into evidence. Say, Your Honor, I wish to enter the ticket of the day in question into evidence, and I want the court to take judicial notice of the fact that it was signed under duress. Something like that.
Yeah, well, my whole statement behind all of that stuff is I was pulled over by a female police officer, and considering the fact that she easily weighed, almost 100 pounds less than me and was several inches shorter, that's like one of the best ways to get shot. I mean, as we've seen from a number of videos, is all you have to do is frighten a female cop and wind up dying. So, I was definitely not feeling safe, especially once backup arrived and it was two of them versus one of me.
Right. Yeah. The best video I've ever seen with, and by the way, it's in the mega folder that I put, is in it's under Right to Travel video, and if you guys want to download that, this guy pretty much takes care of everything on the side of the road. He makes all the correct arguments, and they let him go because they had to. So, and most of that information that he talks about is in the rest of this folder. Yeah, actually, yeah, I can probably type the quote into chat here. So,
I may add something to what all is being said here. Something to keep in mind too, not just the binder and the right things to say, but always record everything. Get as many cameras as you can on the cops as they're pulling you over too.
yeah, having a camera system in your car is obviously would definitely be a great thing to do. And even if you just have your phone, which is what this guy did in the Right to Travel video, he just had his phone and was pointing his phone basically at himself, and then would kind of tilt it over to get a look at the cop every once in a while. But that was what he did. So yeah. Also, either just doing that, or if the minimal of what you have is just even a voice recording, just a sound recording device, that's better than nothing, so that you get the entire stop recorded, and then of course you'll want to enter that into evidence. And remember, that's something that you always want to do. And just as far as rules of court are concerned, read your state rules of court, because if you're going to be stuck in one of their inferior courts, then make them follow the rules, and you have to follow them too. As far as when you enter evidence, say like at a motion hearing, you say, Your Honor, I now enter into evidence Exhibit A, or admissions of evidence A, however you want to state that. And then that gives the other side opportunity to object to the entering of that evidence. But if they don't object, then it is entered as evidence onto the record. Otherwise, it's not there. So you have to follow whatever the rules of court are in order to properly enter evidence onto the record in a court case. Just filing it into the court case is not enough. You have to then enter it at some point in time in open court. Like I said, you can do it in a motion hearing. You could probably do it in a pretrial conference, most likely. But sometimes they get a little bit pissy about that if they're not ready to have an argument about something. So that's why you schedule a motion hearing. So after you filed a motion to dismiss, or you have filed a countersuit, you then contact the other party, or sometimes the clerks will do it for you, or really the best way to do is to contact the judge's judicial assistant. Contact the judge's judicial assistant, say, hey, I have a motion that I filed onto the court case. I need to have it scheduled for hearing, right? And then what the judicial assistant will do is they'll look through the calendar of the judge and say, okay, well, we'll schedule it for such and such date. And you say, thank you. and you say to the judicial assistant, should I contact the other party? And usually they'll say, no, we'll contact them, or I'll send them an email or whatever to the district attorney, because they talk to them all the time. And then you have something scheduled for calendar to be heard. Otherwise, if you don't schedule things, nothing ever gets heard. So make sure that you do that. Well, Laporte, if you're talking about a hearing with a jury, that's different. If you're talking about filing a countersuit wherein you demand a jury of your peers, then that's different. And that's not, juries usually don't hear motion issues. That's a full presentation of when you actually do your full presentation to the court or to the jury at a trial. And in case anybody doesn't know this particular, I guess, class, if you will, there's a course, a law course called Jurisdictionary, and I think it's like $250, something like that. It's well worth your money, and you can buy it online, and it gets sent to you. And what it is it's basically a course. It's a course in equity about how to file motions, what to put into a motion, how to argue a motion, and all of the procedure that happens in a court case from start to finish. And yeah, I do have it on Mega. It's on, well, for the lifetime members, it's on the VSOF online library. But it's better to just, he's probably updated it anyway. It was a course that the man's name, I believe, was Dr. I think it was Dr. Richard Greaves. I think it was Richard. I could be wrong. Anyway, there was a video that I believe Blue Star posted in main chat. Let me scroll up here just a little bit here. Posted a few days ago, and it was an interview with Mr. Greaves on, yeah, here it is. And it was on band.video, which is Alex Jones's site. I'll put it into main chat here. And it's an interview with him talking about how to win in court. And so I highly suggest that everybody watch that video and then get his course, because yes, I can cover a lot of various different things, but he laid out that course years ago, step-by-step process how to do it. And yeah, that's his website, howtowinincourt.com. So that's the link that Janice put up above. So okay, so with that, does anybody else have anything else to add? Let me scroll through chat real quick, make sure I didn't miss anything.
Yeah, I got all the binder and stuff ready, and have been traveling around. I think that the private plate on the back of my truck I got from freedomfromgovernment.org. Trent Goodbody has that site, and he's got a lot of pretty good stuff on his site too as well. But I've had two cops behind me and vote not at the same time, but they just went right around me. Like, it seems that the private plate is kind of a deterrent. Of course, I was in the countering county to the county that I filed the doc set on, and when I sent the doc set in, I attached an affidavit stating that there was going to be a national traveling in your county, just with the description of my truck, and it's not going to have state license plates on it. So it's like, I wonder if and of course in the document it says notice to principal is notice to agent, notice to agent is notice to principal. So it's like, they should all be informed, at least in the county that I filed it. But in the neighboring county, which is Traverse County in northern Michigan up here, I had unbeaconed Dodge Charger with a blue stripe down it. My fuzz buster was going off, and we're looking around. We're like, where's the cop? We don't see him. All of a sudden, he comes out from behind me, passes me by, and keeps going. So it's like, yeah, you had to have seen it on the back of the truck. So I think, you know, all the talk about going to court, I haven't been pulled over yet, but I always know. I think I may even heard you say it, Zen, that don't go into court unless you're the plaintiff, is the way I've heard it. So it's like, even if they give me a ticket, I don't sign it or whatever, it's like, I'm going to send them a file of shit.
Well, yeah,
And
that's the
3 days
yeah.
after they give me.
The point of being a plaintiff is how you have to file a countersuit. That's the point of filing a countersuit in a court of record that proceeds according to the course of the common law. And I covered that information extensively in the class that I did on on the ins and outs of court. I covered basically how to do the countersuit in the ins and outs of court. And the ins and outs of court, I believe I put into the, if I put it into the announcement section, I know I have it in the life members room. Let me scroll up here.
But also, before, like, I've watched 50 videos on the right to travel and how cops end up, what they have for comebacks when people say, no, I'm traveling in a private automobile and not in a motor vehicle, and the cops just shrug. They go, oh, it has 4 wheels and a steering wheel. It's a motor vehicle. So it's a matter of having what to put them in place for, and that's what I came up with, the specific definitions. And like I said, I think I'm going to add the definition. I found it in another book of private automobile. There's actually a definition in that. So it's like, if you have these definitions, just to set them straight on what they think, that they think everyone's a driver and everyone's a motor vehicle. They're trained to think that way. And it's like, if you have the definition straight from law dictionaries. And of course, if they try to argue with me about that, I'm going to look right at them and be like, if I'm more familiar with law dictionaries than the law enforcement officer standing in front of me accusing me of something, then something's seriously wrong with this picture. And that you end up speaking in power. There's another big thing that helps. It's like, yeah, you have the right to remain silent, but if you are careful with your words and you speak in power, you'd be amazed at how much cops will just shoot their eyes straight to the ground and they won't even look at you, because they know that they're being shisty as fuck. And it's like, if you stand in your power, don't act scared of them so much. Don't act cocky, but don't act scared of them. And you'd be amazed at how humble 90% of them will get if you just act
Right.
without being belligerent, without calling names. You know what I mean? Because set certain rules for yourself. Don't cuss a whole lot when you're talking to them. Be professional, all that, but don't look scared, because what are they? They're the dogs. You know what I mean? The lead think that we're all cattle, and they're the dogs, the dog tags and the dog things. And how do dogs, real dogs, act around you? They can smell the fear and they will fucking pounce. So make sure you don't show your fear and act a little bit scared, because they're going to go, oh, well, I don't care if this guy knows what he's talking about, we can coerce this guy and make up some shit. But if you look like you're standing in your power, they may just be like, well, okay, we're going to go find another mouse to chase.
Yeah, that's usually what I do. Particularly one of the first things, like I said, that I always say to them is, with power, is, I don't have any contracts with the corporate state. What do you want?
I've said things like that, but man, maybe it's something about the way I look or the way I say it, but I get so much talk back, and I get so many cops trying to beat me down. Maybe I'm too arrogant about how I say it. I don't know, but
Well, hence is the reason. Yeah, hence is the reason for having and putting together the binder, so that let the binder speak for you. So basically, all you have to say with your confidence is, I'm putting you on notice of everything that's in this binder, and I highly suggest that if you do not understand what's in this binder, that you call a supervisor and let them read it. Because if you continue to move forward, you're going to be in 100% liability to me.
Right. And what I have in the front of mine, or the other gentleman speaking says he hasn't filed his document set yet, but that's what I have in the front of my binder, is the Declaration of Nationality and the fee schedule. And I'm going to break out this binder. If it even comes to that point, I'm gonna tell that I have kind of a spiel kind of laid out, to where it's like, do you suspect me of committing a crime, when it gets to that point, and if that I have committed no crime, they've committed a crime by turning on the emergency use beacons. But if it comes to the point they just want to know who I am, they're trying to identify you, I'll say, I'll tell you what, I'll present you with some information, but not only will let you know who I am, but we'll clear up all the misunderstandings of the difference between a motor vehicle and an automobile. Now I have the binder, and of all the Supreme Court, there's like, I gave you like 5 or 6 pages of Supreme Court rulings. I highlighted the important ones in my binder, and when I get the binder, I'm going to say, look, I'm going to hand this to you, but I'm going to give you a quick overview. And I open up the binder, and on the inside of the front cover of the binder, I have the fee schedule and the Declaration of Nationality there, and I'm going to point to that first, and I'm going to be like, this here shows you that I'm Brian Dale, House of Smith, and this is the fee schedule. The amounts start on page 6, and I'm going to look them right in the eye and go, I would review this first if I were you.
Right.
And then I'm going to kind of browse through the rest of it, and I'm going to go, look, here's some Supreme Court rulings on the right to travel, and if they say you don't have a right to travel, and I'm going to go, well, I wasn't asking you if I had a right to travel. I know I have a right to travel. The proof is right here in this binder. Here's some definitions toward the end, and at the very end is the right to locomotion. And I'm going to shut the binder. I'm going to go, take that. I'll be like, go review that. I'm going to look at the clock, and I'm going to go, you're on the clock starting now, and let them take it. I don't know how well it's all going to go over. Like I say, I haven't been pulled over yet, but
I would give them a little bit of a grace period. I'd say, I'll give you 10 minutes to look that over. At the end of 10 minutes, I'm going to have to activate my fee schedule. I would say something like that, so that you're not being...
Yeah, you're not expecting them to have foreknowledge of things.
Yeah.
The contracts that you have laid out.
Yeah.
Because you don't know. They might be a rookie and might literally just be operating off of whatever the hell they learned in Cop Academy, all 6 weeks of it or whatever.
Yeah. But anyway, just to make another point, I did post the ins and outs of court class, the April ins and outs of court class. I'm also going through some video editing of that I'll probably repost it later. But anyway, that's the totality of the all-day law class that I did back in April. The mega folders underneath it, so that you guys can look through that information and understand the difference between a court of record, understand how to do things in court. So that basically that course, coupled with Dr. Greaves' jurisdictionary course, which we already had the link in chat for. If you go through those two things in their totality, there won't be an awful lot that you won't know how to do in court. So with that, if there's anything else. Oh, okay, so that's what that form is for. Okay, thank you, Laporte. I didn't know what it was for. So, because that Form 700 is about the transparent financial statements that public servants complete every year. Okay, so it's like it's like a state open records request act then for their records. Oh, the other funny thing about that, as far as records and their liability is concerned, strangely enough, I've seen. Now this doesn't deal with traffic, but I'm going to pull it around back to traffic in a second. I've seen situations where they'll pull the financial statements of the judges. They'll find out that the judges have some sort of funds or some various different stocks or mutual funds that contain various different financial instruments pertaining to mortgages, or might even pertain mortgage-backed securities. And what people have done is that because like all of the judges have this, what they've done is they've filed motions to recuse themselves based upon a conflict of interest, and it works. It works quite well. The other thing you can do, now getting back to the traffic thing, is that you can ask the judge, do you have a driver's license, Your Honor? Because if he has a driver's license, then he's in a contractual obligation with the state as well, then arguing or trying to administer or in equity determine whether that contract itself is valid or not. And that, again, I would see as being a conflict of interest. But that's kind of I want to say it's a moot point, but it's a weaker argument. But it is just something else to add. Okay, so I think that's everything else. I think I covered everybody else's questions for tonight. So we can we can have another class like this in case, like an updated class where we can kind of go over and cover back and forth about what people have done for their court cases. I would also like to have anybody that does have a template for any court case that's worked regarding a counterclaim. Feel free to email it to me at vsof@protonmail.com, and I will make sure that I also add it into the file. And as I said, the file will continue, as particularly the list. We'll expand out the list as far as what needs to be in the binder, and I'll also expand out what's in the folder, in the mega folder, for any court paperwork regarding dismissal and other tools, if indeed we come across some more of it. So with that, we're about half an hour over time, which is fine. But with that, I'd like to thank everyone for coming to the Vocational Science Freedom Saturday Night Civics and Sovereignty class. I hope all of you learned something, and I hope all of you will help in continuing to expand out this information, because it is one of the most critical rights that we all have. And so with that, I thank you all for coming, and I hope you have a wonderful rest of your weekend, and stay safe and stay sovereign.